Good day, guys. Good day. Today we are going to be reading from the book called Suits in Chancery. And you can get this book, go online, download it. It's 1,236 pages only. And basically, this is, look at it right here. It says a treatise on the suits in Chancery, setting forth the principles, pleadings, practice, proofs, and process of jurisprudence of equity, and giving numerous illustrative forms of pleadings, writs, orders, reports, decrees, and other proceedings in suits in Chancery from their beginning to their end, besides many practical suggestions for solicitors and masters. Cursus Curia et lex curia. I know. Okay, let's look at what this is really quick, right? Cursus Curia. What is this? What is Cursus Curia? What is that? It says it was created by the Pope Urban III. Which means the Roman Curia. Oh, okay. It means Roman Curia. What is? The Roman Curia, Latin word, comprises of administrative institutions of the Holy See. Isn't that interesting? Curia in medieval and later Latin usage means court. It's talking about administrative court. That's what it is. The Roman court. Okay, here we go. See here. Cursus Curia. Here we go. And lex curia. It's very interesting. You can look it up yourself by Henry Gibson. Let's start. I am going to go all the way to 27 because that's where it actually starts. Part 1. The Chancery Court, its history, jurisdictions, and principles. This is the juicy stuff. He starts off with the juicy stuff, right? The history of the Chancery Court. He's going to talk about Article 1 is going to talk about the origin and evolution of equity in jurisprudence, and Article 2 is going to talk about the history of Chancery Courts of Tennessee. Okay, and all of this. So let's start. 1, and again, this is Article 1. Yeah, it's Article 1. The civil law, its development. The system of jurisprudence called equity was originally largely derived from the civil law of the Romans, and its early development in England was similar to the development of an analogous system in the jurisprudence of Rome. So Rome, so they say Rome fell, but obviously their civil law kept going. Therefore, in endeavoring to trace the origin of the Chancery Court, it may be well to notice briefly the development of the civil law. The early laws of Rome, like the old common law of England, were exceedingly stern, rigid, formal, and arbitrary, paying little attention to abstract right and justice. Their judicial proceedings were technical to the last degree. Absolute accuracy was required in complying with the established phrases and acts in the enforcement of civil rights. Any omissions or mistakes of a word or a movement was fatal. As civilization, however, progressed in Rome, subtle technicalities gave way to simpler methods of pleading. But even then, it was found that cases occasionally arose to which the improved formulas were inadequate. These extraordinary cases were decided by the praetor without being referred to the ordinary tribunal, and without being hampered by any technical requirements as to the proper formula or kind of action. He himself determining both the law and the facts of the case. The complainant stated the facts of his case. The defendant set up his defense. And the praetor decided. Oh, praetor, what is this? Praetor. Praetor. What is this? Praetor, also praetor, was the title granted by the government of ancient Rome to a man acting in one of two official capacities: the commander of an army and as an elected magistratus, a magistrate. There you go. So magistrates come from Roman law. Isn't that interesting? Sheesh. Magistrates come from Roman law. That is incredibly interesting. Okay, where are we? Let's see. The extraordinary cases were decided by the magistrate without being referred to the ordinary tribunal. And without being hampered by any technical requirements as to the proper formula or kind of action, he himself determining both the law and the facts of the case. The complainant stated the facts of his case, and the defendant set up his defense. The praetor decided, the magistrate decided. This extraordinary method of determining suits, so simple, so free from technicalities, so easily molded to the exigencies of every case, was found so superior to even the improved formulas that eventually it superseded them and became the only mode of procedure, much as in many of the states and in England, the procedure by bill and answer has supplanted the rigid formulas of common law actions. Not only were the pleadings thus simplified by the Roman jurists, but the law was correspondingly improved, and a deliberate and persistent effort was made to bring their jurisprudence into perfect harmony with an absolute impartial equity that should do equal and perfect justice to all. Isn't that interesting? And thus was perfected that system of jurisprudence known as the civil law, from which are derived many of the maxims, principles, and doctrines of equity, now followed and enforced in the Chancery courts. 2. Evolution of equity in England. The development of the extraordinary jurisdiction of the Chancery Court of England was similar in its causes, progress, and results to the development of the system of equity in the Roman law, as already intimated. In England, the king was regarded as the fountain of justice. Interesting, right here in Belize is the same thing. They regard the king as a fountain of justice. And when any person conceived that he had been wronged, either in court or out of court, he had the privilege of petitioning the king for redress. Privilege. So the king had to give him that privilege, and as soon as you become privileged, you get a privilege from the king, well, you have to become a subject, as far as I know. But anyway, let's continue. The king, being unable to hear and determine all of these complaints because of their number and complexity, generally referred them to his chief secretary, who was called his chancellor. So chancellor is a secretary. Okay. This officer was an ecclesiastic trained in the law of theology of Rome. So the secretary of the king was trained in ecclesiastic law. Isn't that interesting? And was sometimes called the keeper of the king's conscience. When thus directed to adjudicate the rights and determine the remedies of those petitioning the king for justice, the chancellor naturally had recourse to the civil law of Rome, being most familiar therewith, and also finding therein diviner sort of justice and a simpler and more efficient form of procedure. Besides, these chancellors, who were generally very able and very learned men, were no doubt disposed to regard the English common law as a barbarous code compared with the Roman civil law. Man, that is interesting. So this ecclesiastic chancellor looked at the common law, English common law, and said, man, this is barbarians deal with this right here. We got to bring in some civil law right here from Rome. And that's interesting. The chancellor's office was the chancellor's office was one of great trust and confidence. He was the king's advisor and confidant, the chief member of his council, and the keeper of his great seal of state. He is spoken of at a very early day as one who annuls unjust laws and executes the commands of a pious prince, and puts an end to what is injurious to the people or to morals. 3. Character of the first Chancery suits. The chancellors, following the example of the Roman praetors, applied the equitable principles of the civil law to the determination of all suits referred to them by the king. The suits thus referred were generally 1. Applications to obtain redress for injuries and acts of oppression where from the power of the offender, or for any other case, a fair trial in the ordinary courts could not be had. 2. Cases where there were fraud, deceit, and dishonesty beyond the reach of the common law. And 3. Cases where the common law was inadequate to the requirements of justice. In those times of disorder and oppression, many were the appeals to the king by the poor and the weak for protection against the rich and the strong, the local magistrates being often overawed, and many were the complaints of want of remedy at law. The king, unable to give personal attention to so many petitions, finally conferred upon the chancellor full authority to give relief in all matters of grace, as these applications for redress were termed. That's how it was termed. Applications for redress were termed grace, matters of grace. And from this period, petitions began to be addressed to the chancellors themselves and not to the king. This delegation of authority was made in the year 1348. Wow, that's a long time. And in the next 50 years, the equity jurisdiction of the chancellor was clearly established. 4. Principles on which the early chancellors acted. When matters of grace were thus referred to the chancellor, he issued a writ commanding the party complained against to appear and answer the complaint and abide by the order of the court. The principles on which the chancellor based his decisions were those of honesty, equity, and conscience. By conscience was meant those obligations one person is under to another to exercise that good faith the other has a right to expect. On an application to Parliament for redress, the petition was referred to the chancellor with the command, "Let there be done, by authority of the Parliament, that which right and reason and good faith and good conscience demand in the case." Matters of grace being thus brought before the chancellor as the keeper of the king's conscience, and he being required to do justice in the king's name, he felt under no obligation to determine the rights of petitioners by that law of which they had fled to the king for relief. And, for reasons already stated, the chancellors at an early day adopted the equitable principles and simple procedures of the civil law of Rome, adapting them with wisdom and prudence to the emergencies of the particular cases. The matters referred to, them being matters of grace and of conscience, the chancellors felt bound to decide the cause according to conscience. The jurisdiction of the chancellor being thus established upon grace and conscience, and his judgments being in the name of the king, and by his authority, whenever the courts of common law were inadequate to the demands of justice, the party unable to obtain relief therein would have recourse to the chancellor, who in his court, called the High Court of Chancery of England, undertook, like a praetor of Rome, to administer an equity not found in the law, himself determining all questions both of law and fact, and rendering a decree adapted to all of the exigencies of justice. 5. The common law as compared with the civil law. The common law was then utterly incapable of doing complete justice in many cases, and in not a few cases it furnished no remedy or relief whatever. It had certain rigid molds or formulas into some one of which every cause of action had to be cast. And if the cause could not be run into any of these molds, there was no redress. And if it could be run into one of the molds, only such redress as the formula gave could be had, regardless of the equities of the case and the real rights of the parties. The fictions, formalisms, and arbitrary technicalities of the common law and its dialectical refinements were inexplicable and incomprehensible jargon to the public, and often a costly mockery of justice to the litigants. Those who asked for bread were often given stone, and those who applied for fish sometimes received a serpent. So basically they're saying that the common law was just very, very inadequate. It couldn't really give proper remedy. It was a lot of, incomprehensible jargon to the public, kind of like what we have right now. So equity, on the other hand, disregarded forms. See, because equity regards substance over form. Ignored fiction. See, equity ignored fictions, subordinated technicalities to the requirements of justice, and indulged in no dialectical refinements. Let me look this up. What the hell is this word? Relating to the logical discussion of ideas and opinions concerned with or acting through opposing forces. Dialectical. Okay, that makes sense. I don't know why I was saying dialectical. No dialectical refinements. Its pleadings were simple and natural, and its doctrines were founded upon the eternal principles of right as interpreted by a lofty Christian morality. Its great underlying principles of right as interpreted by the lofty Christian morality. Okay, wait a minute. Wait, what am I saying? Okay. Its great underlying principles, the constant source, the never failing roots of its practical rules were the principles of equity, justice, morality, and honesty enforced according to the conscience and good faith, and so adapted to the requirements of each case and the complications of business affairs, that the rights and duties of all parties were fully determined. 6. Some of the deficiencies of the common law. The common law then was not what it has since become under the benign inspiration of the Chancery jurisprudence. At common law, 1. A vendor's lien could not be enforced. Interesting. A vendor's lien could not be enforced. 2. A fraudulent conveyance could not be set aside. 3. A defective instrument could not be reformed. 4. A mistake or an accident could not be effectually relieved against. 5. A debt, note, or account could not be assigned. Under common law, you can't do this thing. That's merchant law. Because, it's in merchant law, you have the right to do that. 6. A resulting trust could not be set up. Wow, that's interesting. A beneficial interest in property could not be enforced. A void instrument could not be cancelled. Oh man. So even if you void it, it's not going to cancel it. 9. A will or a trust could not be construed in advance of actions therein. 10. Testimony could not be perpetuated. 11. A trust fund could not be impounded. Okay. 12. A specific performance could not be decreed. 13. An equitable partition of land could not be had. 14. A deed could not be declared a mortgage. 15. Title to land could not be effectually quieted. Wow, you can't get quiet title under common law effectively. That's interesting. 16. Waste, trespasses, and other violations of rights could not be stayed. 17. A forfeiture of penalty could not be relieved against. 18. A set-off could not be obtained. Shit, I think I'm winning common law because I'm having trouble getting a set-off right now. Anyway, 19. Land cannot be redeemed from a mortgagee. 20. A lien on realty could not be enforced. 21. A loss of instrument could not be set up. 22. The estates of minors and lunatics could not be administered. Wow. 23. A pro rata distribution of assets could not be had. 24. A contract could not be apportioned. 25. A cloud could not be removed from one's title. A cloud. Okay, cloud could not be removed from one's title. 26. Securities could not be marshaled. 27. A partnership could not be wound up. 28. A subrogation or contribution could not be obtained. Wow. 29. Trusts were not recognized and could be violated with impunity. Under common law, listen to what it says. Trusts were not recognized and could be violated with impunity. Wow. 30. A wife's equities did not exist. 31. A title bond was no defense to an action of ejectment. 32. An injunction could not be had in any case or for any purpose, however great the wrong. 33. Receiverships were unknown. 34. Equitable rights and interests were not recognized. And 35. Frauds could not be adequately remedied. So, moving on. 7. How the law has followed equity. Under the influence of the principles of equity as administered in Chancery, the rugged features of the common law have grown constantly more and more smooth and humane, and its capacity to do justice has constantly increased. The evolution of the law of England and in America has been on the lines marked out by equity, until, in the language of Lord Hale, by the growth of equity on equity, the heart of the common law has been eaten out. What? By the growth of equity on equity, the heart of the common law has been eaten out. Okay, to show the effect of the principles and doctrines of equity upon our own statutes, the following illustrations are cited. The law 1. The law in reference to gambling and wagering contracts. 2. Wait a minute, so what am I reading right now? So it says here, to show the effect of principles and doctrines of equity upon our own statutes, the following illustrations are cited. The law in reference to gambling and wagering contracts. The whole law of landlords. Oh, that came from equity? Mechanics, laborers, and other liens. Yep. The law of notice through registration of deeds. That came from equity, okay. The pro rata distribution of insolvent estates. 5. The apportionment of rents. 6. The provisions for the benefit of married women. 7. The guardianship over the estates of infants and persons of unsound mind. 8. The allowance of set-offs. 9. The right to sue upon a remedy of interpleader. 11. The right to set aside the satisfaction of a judgment. 12. The proceeding by garnishment. 13. The right to a sale of land for partition. 14. The proceeding at law to remove a cloud from title by suing a claimant not in possession of ejectment. 15. The right to defend by title, bond, as by deed. Nice. The power to sell the property of infants and lunatics for reinvestment or support. Wow. So see, equity made this happen, but at the same time, it made it to where if the people didn't, if the people were considered infants or lunatics because they're, not competent, then their estates were invested on. That's kind of like what's happening right now. 17. The right to impound the property of absconding debtors. Again, that's exactly what's happening right now. They're impounding our bodies when we go to prison. That's what's happening. Where are we? Where are the remedies by motion? Allowed sureties. The removal and appointments of trustees. 20. Giving the right to take dispositions at law. 21. Making parties witnesses. 22. Providing for the perpetuation of testimony and the taking of evidence. Devene esse. It says 45. Let's see, 45. They're talking about code. Okay, cool. Okay, where am I? Okay, here I am, right here. 23. Allowing lost instruments to be proved and authorizing lost records to be supplied. For all of these statutes are mere enactments of rights recognized and enforced, remedies employed, defenses allowed, and procedures used in the Chancery Court by virtue of its inherent jurisdiction, and were wholly unknown to the common law. Their recognition in our courts of law depending exclusively upon the statute, and the statute being suggested by the practice of equity. 8. The divine law of justice and the rule of the decision. The statement often made that the Court of Chancery was established to mitigate the rigor of the common law and to supply its defects is not wholly true. No, okay, it's not really that true. Okay, so what is the truth? And this court was established to do justice, regardless of any and all law. The king deemed it a duty imposed upon his conscience, both by his oath and by religion, to decree justice. And in decreeing justice, he deemed himself bound rather by the divine law than by human laws. That makes sense, because humans are not man. It's human, like a shadow is a color of man. It's a human. Shadow is a human. Man is a man. This is just a little example. And when the chancellor acted in his stead, he based his decisions not upon the law of the land, but upon honesty, equity, and conscience. For so was he commanded to do in exercising the king's prerogative of grace. In short, the Chancery Court was established rather as a court based on the precepts of religion than as a court based on the rules of law. So the courts of Chancery was a religious derivation. That's interesting. Very interesting. Okay, here we are right here. It is unquestionably true that the harshness of the common law, its unfitness to cope with fraud, its incapacity to do justice in many cases, the defects in its remedies, the opportunities it gave the strong to oppress the weak, and its general inadequacy to meet the requirements of equity greatly contributed to perpetuate the existence of the Chancery Court and to enlarge and justify its jurisdiction. Nevertheless, the vital principle from which the court sprung was the prerogative doctrine that the king was the fountain of justice. If he is not the fountain of justice, he can't be the king. So in order to be a king, he has to be the fountain of justice. It's like taking an oath of office. You can't have that office if you're not standing by your oath. That's why you have that position, because you took that oath. Fair exchange. You give the oath, you'll get the responsibility and the title. Makes sense. Okay, so let's continue. And that when a citizen could not get justice in the ordinary courts, he might come to this fountain. The king, in administering justice in such cases, deemed himself above all the laws and customs of his realm, and bound only by his conscience and his will. As it was not a matter of right in a citizen to draw on this reserved source of justice, when remedy was given, it was deemed granted as grace. 9. Other causes contributing to the establishment of the Chancery Court. As the Chancery was the office out of which all writs at common law issued, the Chancellor retained cases for his own disposition when the facts were such that no common law writ was adapted to the requirements of the case, or when the common law courts were unable to furnish adequate relief. And some contend that herein originated the extraordinary jurisdiction of the Chancellor. In this class of cases, the Chancellor determined the matters in dispute so that the court of the king might not be deficient in doing justice. But it is believed that the equitable jurisdiction of the Chancellor originated mainly, if not exclusively, from the reference to him by the king of petitions for justice and redress, as already stated. It is unquestionably true, however, that had it not been for the deficiencies of common law, the number of these petitions to the king would have been comparatively few. Meaning, if common law was working well and did provide justice, no need for the king to step in. But because people were running common law and they were basically taking advantage of each other, considered heathens and assholes, the king had to step in. And that's interesting to know. When the lay chancellors succeeded the ecclesiastics, no material changes were made in the jurisdiction of the court. Its system of jurisprudence was, however, enlarged and made more comprehensive. Precedents were more closely followed, and the decisions of the chancellors more carefully preserved. But the equitable principles of the civil law were as fully enforced, and the peculiar proofs and practice of the court in all things continued. the late Chancellor being greatly aided herein by the masters in equity, who were permanent officers of the court. Thus was established at the High Court of Chancery of England, and thus originated that grand system of jurisprudence known as equity, both maintaining their existence by virtue alone of their inherent merits and their wonderful fitness for their purposes of administrative justice. It's all trust. It's all trust. Administrative justice is all trust. So it may be well here to remark that by an act of the British Parliament, which went into operations in 1875, all the great courts of England, including the High Court of Chancery, were consolidated, and a system of pleadings and practice adopted similar to those in use in Chancery. The Act of Parliament also, so this happened in 1875, they all just got consolidated. They just put everything together. The Act of Parliament, I'm right here seeing, the Act of Parliament also provides that in all matters in which there is any conflict or variance between the rulers of equity and the rules of common law, with reference to the same matters, the rules of equity shall prevail. That's right, substance over form. And thus in England, the triumph of the righteous principles of equity over the rules of the common law is complete and no doubt final. Alright, this is all for right now. I hope you guys liked it. Again, Suits in Chancery, Henry Gibson's. You can look this up. Just go and all you gotta do is type it in. Go download Suits of Chancery, Henry Gibson's, and you're gonna see, oh, this is free, guys. Free information. So, I hope you liked it. Download it. I hope you look into it some more. I'll be reading some more later on. For now, peace and love.